Well, hello. It's great to be with you today for this 2021 annual ADA Forum. And today's topic is about copyright and contract. And as the title says, it's really been an enduring question because in fact, it's been around for at least 20 years. In fact, in 2002, the government had issued the report of the Copyright Law Review Committee entitled Copyright and Contract. And I have to say that I was on the committee at that time, and it was certainly a very interesting challenge for us to work on this review and to publish this report. The report examined the exceptions in the Australian Copyright Act, and the government was particularly interested in whether by that time, that is 2002, contracts were being used to exclude or modify the exceptions, and whether or not it would be possible to displace the exceptions set out in the legislation by contractual means. That is, whether or not it should be possible to do that and to come to a conclusion on that. So these were the two main questions, and by the end of this large report, they had been answered. I should say a little bit about the Copyright Law Review Committee, what it was. It was a specialist body that was set up to advise the Attorney General, and it existed from 1983 to 2005. And in that time, it conducted over a dozen reviews, including some quite significant ones, covering a wide range of topics such as moral rights, computer software protection, the whole question of simplifying the Act, which seems to have been something that hasn't been achieved over a very long period, and a number of others. In 2001, and in fact right at the point where the reference on contract and copyright was issued, its fourth chair was appointed in the form of James Lahore. After 2005, reviews of copyright law continued, but they were more likely to be done on the instigation directly of the Attorney General's Department, or alternatively another law reform mechanism such as the large reference that went to the Australian Law Reform Commission in 2011, 12, 13, and others of relevance, not least the Productivity Commission that a lot of us took a considerable interest in a little while ago. Now, the task that was given to the Copyright Law Review Committee back in 2001-2 was to consider four principal issues. One, the extent to which electronic trade in copyright works is subject to agreements which exclude or modify the exceptions in the Act. Two, the extent to which that's happening other than online. That is, does it already exist in the offline environment? Three, the ability by owners or users to enforce such agreements. And four, whether such agreements should be enforceable under the Act. Now, as well as those first four questions, there were a range of others. The relevance, if any, to the Circuit Layouts Act, suggestions about implementation, including any non-legislative possibilities, incidental matters arising, and there was also a request that the review represent all of the relevant views on the questions that were posed. The review noted that principal exceptions such as fair dealing are fundamental to defining the copyright interest, while others such as statutory licenses are not true exceptions, might more appropriately be termed limitations. That's an interesting distinction for people who are involved in copyright law reform to consider, the distinction between exceptions and limitations. The review found that the issues were indeed real issues, and that they arise in both the electronic and the non-electronic or pre-electronic environment. There was quite an issue at the beginning of the review about whether this was really a problem. And that was generated in part by a view that came from some quarters that no, there's no significant incidence of agreements that have this effect. But in fact, when it came time to gather the evidence, the committee found that it was quite substantial. A lot of it came from education, library and legal offices in institutions that consume electronic material in large amounts. The evidence was convincing, and I have to say that right at the beginning of the process, some members of the committee themselves wondered whether there was such a thing as contract overriding copyright to any degree that need be of concern. And in general, the interests that represent owners, such as the collecting societies and others such as the Publishers Association, stated that they weren't generally aware that these agreements existed. One of the things that one notices from looking at the report is that the ADA, which itself had only just been founded shortly before, was quite prominent in the discussion in the text about various views on the matters that were arising. Now, the review did find that offline trade can be subject to these kinds of displacing agreements, but it also realised in looking at it that by far the main area of concern was the way the contracts had exploded, really, in terms of their usage to seek to direct the terms of trade in which copyright material available electronically could be made available, and to, in so doing, lift the level of protection above the bar that's set by the existing exceptions in legislation. So, as I say, the electronic trade showed much evidence of these agreements. By its nature, it allows the notion of these contracts to seem to be cost effective and enforceable, and the committee found that. In turn, the problem is magnified by the fact that a contract might cover a very large range of material provided in a bundle, and these bundles were by now becoming a thing in scholarly and educational markets. And it also featured a growing amount of material that was being released with mass market end user agreements, click wrap, shrink wrap, the kinds of things that are absolutely second nature to us now, but were also part of the discussion that occurred. I might say that one way that the committee operated was to hold, not only call for submissions, but to hold public meetings, a public forum in particular in Sydney, I think was rather compelling in a couple of ways. One was the attendance by people whose main job for their institutions was to provide legal advice as solicitors in those offices on these agreements as they came to hand. Well, the critical finding of this review was that, in fact, yes, there is a problem, and it said very clearly, based on its findings, that agreements are being used to exclude or modify the exceptions. Existing remedies are not adequate, and the committee's concluded that therefore there's a displacement of the copyright interest. And it also proposed that action does need to be taken, and it proposed that the Copyright Act be amended to provide that an agreement that excludes or modifies the operation of the exceptions, and it actually in the report lists the 19 cases which it's describing as the relevant exceptions, that the Copyright Act should be amended so that that would have no effect. One of the deep issues that came up, and to anyone familiar with the market for a lot of this material, this is entirely unsurprising, was that a lot of the contracts that govern the supply of this kind of copyright material are in fact drawn up in jurisdictions other than Australian. So although that wasn't a specific reference that was given to the committee, we were asked to be aware of international obligations, but the committee had not specifically been pointed at the issue of contracts drawn up in other jurisdictions. It became evident during the inquiry that this was a significant issue, and therefore there was a recommendation which actually appears first in the text of the report, that the government seek an international solution to private international law issues that relate to agreements. I'd like to make three observations about the process of generating this report, and I should say here that it was very interesting to me personally because I had been appointed to the Copyright Law Review Committee and had the experience of seeing the full range of opinion that when the government was engaging in consideration of copyright law reform would solicit, and to see just how that was dealt with during the process of quite a complex investigation such as this one. The three things that are worth noting before coming to what happened eventually is that the views of the collecting societies were not as one. At the public forum that was held in Sydney during the course of the process, the CEO of APRA in fact made it very clear that he thought that the intentions of the legislature should not be confounded by private contract, and in that regard his view stood out. The second thing is an argument that I think surfaced then, but I still hear now, which is the notion that if you legislate in relation to contracts, then you might have the effect of suppressing contracts that actually give the user a greater than normal provision of access that is greater than that's normally provided by the existing exceptions and limitations. Now, there are a couple of issues with that. One is that this reference was about the interference of contracts on the existing exceptions. So it was very clear what the intention was. And the second is that if the Act were ever amended, you could make it very clear that that intention would be observed. I'd also point out that provision to provide access greater than to the realm of material that's made available observing exceptions and limitations already exists. It's called permissions. And in our time, and indeed the 20 years that have elapsed since this report was done, the huge rise of open content licensing, which specifically gives creators and authors the ability to state that the use that's to be made of their material is greater than that would by default be otherwise provided through the operation of the relevant act in the relevant country. The third point I'd like to make about the process is that although lots of evidence came from very specific areas, at no stage did this review consider making recommendations that might relate just to certain sectors. It's dealing with the law, it's dealing with the principle of whether contracts and other private agreements should be used in any way to overcome the existing exceptions that guarantee a threshold of access in our arrangements in Australia. Well, what's happened in the last 20 years? Not much. No action was taken on the main recommendations. I personally was very interested in whether there would be, because I really wanted to see how the international jurisdictional matter might be progressed. It's not easy, but it was certainly there to be thought about and pursued further. So in this regard, somewhat depressingly, it's a bit similar to the fate of various other reviews that have been undertaken into Australian copyright law. And in effect, the report's essentially been ignored, although it's a very good resource for people who are wanting to investigate this part of copyright law. So thank you very much for listening. I trust that the panel discussion will shed more light on this as well.